All right, it is noon, so we'll go ahead and begin this ELE. My name is Ben Birmingham. I serve as a Chancery Court for the Wyoming Chancery Court, and let me just thank you all for your interest in the Chancery Court and really for the gift of your lunch hour today. And I hope to return that gift with not only some CLE, but some helpful information about the Wyoming Chancery Court. I hope that after today's presentation, you'll have a better sense for where the Wyoming Chancery Court fits within Wyoming's judicial system, where it fits within Wyoming's business infrastructure,
Infrastructure,
the
the
values
values
that our
that our
court
court
adds to these
adds to these
systems.
systems.
And I hope that you will um, come away from this presentation with a better sense for what practice looks like in Chancery Court and how it may differ from practice in other courts and other forums of dispute resolution. So I'll go ahead and provide this presentation, and then I'll try to reserve some time for questions at the end. So let's just start at a basic and general level with what is the Chancery Court. The Chancery Court is Wyoming's newest trial court. It's a specialized statewide court that handles business, commercial, and trust cases. And it handles these cases on an accelerated schedule using a specialized judge with a manageable caseload, using bench trials instead of jury trials, using active case management practices, emphasizing proportional discovery tailored to the needs of a case, and then emphasizing regular settlement efforts. Unlike Wyoming district courts and the Wyoming Supreme Court, which find their origins in Wyoming's Constitution, the Chancery Court is a legislative creation. It was born by legislation enacted in 2019. Chancery Court launched in December of 2021, and when it launched, it was presided over by two district court judges who handled Chancery Court judges in addition to their existing district court caseload. And then I had the privilege of taking the bench in January of this year as the first full-time Chancery Court judge. And over its early years, the Chancery Court has continually been refined by statute and by amendments to its rules. But as a legislative creation, the Chancery Court derives its purpose and it derives its defining core attributes from statute. Legislation articulates the purpose of Chancery Court as serving as a forum in Wyoming for the accelerated resolution of commercial business and trust cases. And then statute attributes to Chancery Court core characteristics like specialization or limited jurisdiction, active case management, working on accelerated timeline, limited motions practice, emphasis on settlement efforts, and bench trials instead of jury trials. And you'll see these legislatively defined characteristics and the legislatively defined purpose really inform and drive all that we do in Chancery Court. They influence our rules, our practices, and our procedures. One of our statutory characteristics is that Chancery Court is a statewide court with explicit statutory authority to hold court in any county in the state. Chancery Court does have a wholly dedicated state-of-the-art courtroom in Casper, in the state office building there in Casper. But let me underscore that we are not a Casper court. We're not an Turner County court. We are a statewide court with a mandate to provide cost and time-effective resolution of disputes statewide. So to serve the entire state in a cost and time-effective manner, we hold most of our proceedings and conferences remotely. We do this to lower cost and increase accessibility. When a proceeding or a case does require an in-person proceeding, we'll typically use our courtroom in Casper, but if all the parties, witnesses, and counsel are located in a specific location or corner of the state and a courtroom is available there, the court's happy to exercise its statutory authority to hold court in any county in the state and will certainly travel to a location that is convenient to the parties, witnesses, counsel. And the location of a bench trial, should a trial become necessary, That's a topic we discussed in our initial case management conferences. So with that high-level introduction, a question you may have is why? Why does Wyoming have a Chancery Court? Why did the legislature create this court? Why did the branch launch the court? Why are business and trust litigants increasingly turning to the Chancery Court for business and trust resolution, dispute resolution? I think this is a fair question. It's an important question, and it's an important question that I like to approach and look at through a lens articulated by Harvard business scholars, dubbed the job to be done theory. And this is an intuitive theory that holds that customers do not merely purchase products or services. Instead, they hire those products or services to do a particular job, to get a specific job done. So product and service providers under this theory should be squarely focused on identifying that job and doing it as effectively as possible. And this jobs to be done theory gives way to a value proposition statement, or a statement that articulates how a specific product or service gets the job done and how that service is distinguished from other services, other providers. And you've no doubt seen these types of statements in marketing materials. The jobs to be done theory and the value proposition statements, I submit, apply just as well to courts and dispute resolution services. Business and trust litigants have their choice of forum to resolve disputes: private arbitration, federal court where jurisdiction exists in federal court, general jurisdiction state courts, or a specialized court like the Wyoming Chancery Court. And when a business or trust litigant selects a forum, they essentially hire that forum to do a job, to resolve the case efficiently, correctly, and fairly. So the Chancery Court's proposition statement and the way we answer this question of why the Chancery Court is this, it's the focused, fast, and fair resolution of business and trust disputes. And I'll use this statement, these three components, focus, fast, and fair, to introduce you to the Chancery Court and to hopefully explain, articulate the value the court offers our state court system and our state's business infrastructure. So focus is perhaps the Chancery Court's most significant distinguishing characteristic. As I've said, the Chancery Court specializes in business and trust cases. That's all we hear. And this is what distinguishes us from general jurisdiction courts in the state of Wyoming. And let me say, I have tremendous respect for my colleagues on the district court bench, and I'll be one of the first to tell you that in many ways, their job is more challenging than mine. It's more challenging due to the weight and variety of their caseloads. And as you can see on this chart of district court cases by type across Wyoming in the financial year 2024, district court judges are hearing criminal cases, domestic relations matters, appeals from circuit courts, juvenile matters, guardianship conservatorships, probate matters, mental health matters, and then general civil matters make up only 12% of the district court docket typically, and an even smaller percentage of this already a small piece of the pie are business and trust matters. In contrast, in Chancery Court, that narrow slice of that already small pie is where we live. We handle business commercial trust cases that are seeking equitable relief, declaratory relief, or monetary relief that exceeds $50,000. And this narrow specialized jurisdiction allows the court to develop expertise and become increasingly effective and consistent in resolving cases. So statute establishes the Chancery Court's jurisdiction, and it enumerates 22 case types that fall within Chancery Court's jurisdiction. I've included the list here along with the statutory and rule reference. I'm certainly not going to read all 22 case types, but let me, at the risk of oversimplifying this, summarize it this way. The court has jurisdiction over three main case categories or buckets of cases. The first would be uniform trust code cases. The second would be intra-business disputes, so disputes internal to a business, disputes over ownership, custody, control, shareholder derivative actions, breaches of duties. And then the third bucket would be inter-business disputes or breach of contract disputes between businesses. So that captures most, certainly not all, but most eligible case types in Chancery Court. I should also note that statute allows the court to exercise what statute calls supplemental ancillary jurisdiction over any case type that's not listed here. So as long as a case in Chancery Court has a claim that fits within one of these 22 enumerated types, if there's a related claim, the court in its discretion and in the interest of economy and convenience for the parties can exercise supplemental ancillary jurisdiction over that case type that doesn't fall within this list of 22. Chancery Court rules really make clear that the Chancery Court does not hear non-business, non-trust cases, and the rules do this by identifying specific case types that don't fit within Chancery Court's jurisdictions. You'll find this in Rule 2. So non-trust cases like personal injury cases, criminal matters, wage worker safety, consumer claims, residential real estate disputes, those fall outside of the Chancery Court's jurisdiction. So that's part one of our value proposition statement focus. The second part is fast or speed. And these two attributes are related. I think you can see how they're related. The court's narrow focus, seeing the same types of cases over and over without competing case types, naturally allows the court to resolve matters more quickly. And by both statute and rule, the Chancery Court's goal is to resolve most cases within 150 days of issuing a scheduling order. And by rule, the scheduling order typically issues 14 days after a defendant answers a complaint or petition. So Chancery Court has that statutory mandate and that goal to move quickly, but it's not the only court with statutory timeframes for resolving cases. The difference is the types of cases that are subject to this prioritization or this expedited relief. So district courts are directed by statute, rule, even constitution to resolve certain matters within timeframes. So in district court, you'll see that criminal matters, juvenile matters, Title 25 matters move to the front of the line, understandably. And this means that occasionally business and trust matters, especially complex matters that require lots of time and management, may yield to these statutory priorities in district court. So those business and trust cases may move down the queue. What Chancery Court does is it offers a forum for business and trust cases where there are no competing priorities that may push them down the queue, instead those cases receive the priority and are resolved quickly. And to put the importance of accelerated resolution into context, let me just note some studies and general criticisms that civil litigation moves slower than the fast-moving marketplace. It may move slower than commercial realities require. One study, it's a bit outdated now, but it's a study of both complex and simple civil cases in state courts nationwide, found that on average, state courts nationwide resolve civil cases in 306 days. And then in federal courts nationwide, the average time from filing to trial is 2 years. I think we're much faster in Wyoming, but nationwide, backlogs have increased nearly 350% over the last 20 years. And this certainly has an impact on commerce. Time to resolution is important, and I mention it here because in the business context, as in most contexts, time is money. And the studies confirm what common sense suggests, which is the longer the litigation, the costlier the litigation. And then beyond those direct, hard litigation costs, there are other costs, opportunity costs, distraction and efficiency costs. So as you all know, litigation is distracting, it's demanding, instead of focusing on improving its products and services and offerings and meeting its clients' needs. Businesses are preparing for depositions, gathering discovery responses, a meeting with counsel on litigation strategy. In most, today even almost all cases, this attention and these efforts are more productively spent on other measures. So with that in mind, let's take a look at the Wyoming Chancery Court's timelines. So the court with this focused and lighter caseload is systematically positioned to resolve business and trust cases in an expedited and commercially sensitive time frame. So since the launching 4 years ago, our average time to resolution has hovered around 115 days. Right now, we're at 116 days from filing to resolution of our cases. And this year, for the first time with a full-time judge, our average time for resolving substantive motions, so motions to dismiss, motions for summary judgment, other types of substantive motions, our average time for resolving those is right around 10 days after close of briefing, if there's no oral argument, or 10 days after a hearing on the motion if there is oral argument. So we have, given our caseload, we're allowed to move quickly, and this certainly isn't to say that we're superior to other courts. It's just to underscore that we're systematically positioned and intentionally designed to move quickly. Our caseload is focused, it's light, we have no competing priorities, so we can move quickly. And let me just also say that this is our first year with a full-time staff, and as the court gains more experience and starts to see the same types of cases and issues over and over, I think you'll see this timeline either tighten or stay the same, even with a growing caseload. I understand that some of you practice in the areas of trust and estates, so let me highlight our timelines in trust matters. Many of our trust cases are uncontested matters. They're matters where the trustee is seeking approval to take certain action or instructions, and there are no parties objecting to that relief. In those types of uncontested cases, our average resolution time is 36 days from filing. And in these cases, if the court needs to hold a hearing, then the court tries to convene that hearing within 30 days of the filing and then tries to resolve the case within 5 days of that hearing. And most often in these uncontested cases, often any delay is attributed to just the time it takes to serve parties or file the acknowledgments and waivers of service and consent to the relief that's requested. In our contested trust cases, our resolution time is an average of 149 days from filing. The way we achieve these accelerated timelines is by employing a formula we found that works, and that formula is early and active case management, where early in the case, and I'll discuss this some later, but early in the case, the court and the parties arrive on an aggressive but achievable case schedule with a firm trial date, and then the court engages in periodic case management status conferences to ensure the case is moving along that previously established timeline. So we have that firm timeline, but then in conjunction with that, the court requires the parties to engage in regular settlement conferences. And that combination of a firm trial date and regular settlement efforts has resulted in expedited resolution in our cases. So we've talked about the fast and focused part of our value proposition statement. Let's discuss the last component, which is fairness. And speed, as we've just discussed, is a byproduct of our specialization or focus. But this narrow focus also engenders fairness. So focus leads to fast and fair resolutions. And the whole theory of a modern business court, like the Wyoming Chancery Court, is that a judge who specializes in these types of cases hears the same types of cases over and over, sees the same types of legal disputes and issues, deals with the same sorts of factual disputes, is dealing with the same types of attorneys and parties over and over and over. Over time, the court will naturally become not only increasingly efficient in resolving these matters, but will become increasingly consistent in handling the same types of cases. And this consistency provides businesses and trust actors with predictability, and then the predictability and certainty can help foster economic growth and encourage investment. By statute, Chancery Court decisions are published. This is another of our statutorily defined characteristics. So by publishing decisions, Chancery Court can help build a body of published decisions that further those twin virtues of predictability and certainty. So this growing body of decisions can give counsel a basis for performing a risk assessment and predicting how a case might be resolved in Chancery Court if tried in Chancery Court. In our first almost 4 years now, we're slowly building this body of published decisions. We've published decisions on business law topics like implied partnership, custodianship, receivership, um, dissolution. We've also issued decisions on the contours of our jurisdiction, certain procedural rules. And some of these decisions are certainly specific to rules and issues applicable in Chancery Court, but many of our decisions are dealing with procedural rules and issues that are not specific to business and trust cases. So even if you don't practice business and trust law, some of the court's decisions on these topics may prove useful. A lot of times they may be topics that won't reach the level of a Supreme Court opinion, so there won't be a generated opinion dealing with or addressing the particular principle or rule of civil procedure. But you can certainly look at these decisions to get a sense for how a Wyoming trial court has applied these procedural rules or concepts. Certainly these decisions aren't binding anywhere, but I think they can be informative and helpful. And we really try to take pride in issuing not only timely decisions, but decisions that are fit for publication, that are thorough, carefully reasoned, well articulated, decisions that help build this body of law that can provide a basis for predictability and certainty. So I'd encourage you to take a look at some of our decisions. Our decisions are posted on the Wyoming Judicial Branch website. You can also access these on Lexis and Westlaw depending on your subscription. And we're currently working with our colleagues in the Administrative Office of the Courts to make our database on the Wyoming Judicial Branch website even more helpful by including short descriptions or topic tags, ways to make it easier for users to navigate these decisions and locate relevant and helpful decisions to the issues before them. If you practice business law in Wyoming, you might even consider signing up to receive notification of when the Chancery Court publishes a decision. You can do so on the Wyoming Judicial Branch website by clicking on the email update button at the top right in that red banner that you'll find on the Wyoming Judicial Branch website. So just to recap those three components, focus, fast, fair, those define the Chancery Court. I think they communicate the value we add Wyoming's court system, the value we add to Wyoming's business infrastructure. But I'd like to broaden our view now to explore where the Wyoming Chancery Court fits not only into Wyoming's systems, but into a much larger nationwide movement. The concept of a modern business court like the Wyoming Chancery Court is not unique to Wyoming. More than half of states, 27 to be exact, have some form of a modern business court. And when I use that term, modern business court, let me note that that's a term that really defies a neat and clean, a tidy definition, because no two state business courts are the same. Jurisdictional parameters, origin, practice, scope all differ. Generally, though, what I mean when I say modern business court is a court dedicated to resolving business disputes, either intra or interbusiness disputes. Courts that are specifically set aside to resolve these types of issues. And while these courts vary in scope and practice and origin, they all share a common characteristic of specialization. That is one judge or set of judges with manageable caseloads specifically assigned to hear business cases and only business cases. And this specialization, in turn, as we've talked about, gives rise to quick and consistent resolutions. The inspiration for the modern business court movement is the Delaware Chancery Court. It's a court I'm sure you are all familiar with. Over 200 plus years, the Delaware Chancery Court developed expertise in corporate law, and it earned a reputation for resolving corporate governance matters quickly and efficiently and consistently, and it built up a body of published decisions that gave um, corporations and practitioners a level of predictability and certainty. And this made Delaware a leading jurisdiction for business formation. Today, 68% of Fortune 500 businesses call Delaware home. And other states took notice and recognized that their states and the businesses within their state would benefit from a Delaware Chancery Court-like experience, which is to say, a specialized court that would handle complex corporate matters consistently and effectively, and that would build up a body of decisions to aid predictability and certainty. So a movement was born based on this inspiration of the Delaware Chancery Court, and the movement started in the early 1990s with states like New York, Illinois, North Carolina, and New Jersey establishing special business dockets, divisions, calendars, programs within existing courts. So by court order, these states created these specialized dockets to resolve and hear business cases. And then the movement continued in the early 2000s. It was mostly confined to the East Coast. So states like Pennsylvania, South Carolina, Florida. And for the most part, these were specialized dockets that operate within existing courts. And for the most part, these were created by court order. Some were localized, others were operating on a statewide basis. And then in the 2010s, the movement spread from the East Coast into the heartland. So states like West Virginia, Iowa, Indiana started business courts. And again, mostly dockets or divisions within existing courts, mostly created by court order. And then Wyoming entered the movement in the latest wave of the business court movement in the 2020s. And this latest wave is unique. I think it's a bit more ambitious in that these four states, Georgia, Wyoming, Utah, Texas, launched their business courts by statute, not court order. And legislation made these standalone courts with statewide jurisdiction. So they do not operate within existing courts. And this modern business court movement is not done by any stretch. States like Oklahoma and Louisiana have taken steps to launch business courts. I understand that Montana has discussed the concept as well. So the movement continues. And these 27 and counting states have launched and maintained business courts for some of the reasons we've discussed. Greater speed and consistency in resolving business disputes, which greater predictability, which attracts business activity and fosters economic growth. And I think the truth is today, in today's competitive marketplace, when businesses are deciding where to headquarter, where to invest, where to expand, one of the many factors they consider is whether a state has a specialized form for resolving business disputes. And if a state lacks such a court, it faces a competitive disadvantage compared to the 27 states accounting that do have one. And there's some indication that this is working here in Wyoming. Wyoming recently overtook Delaware as the state with the most LLC formations. I want to say we saw a 30% increase in business formations in 2023. And I certainly don't want to overstate the Chancery Court's rule, and I don't want to acknowledge that it's difficult to know whether there's correlation or causation. But in my view, it's meaningful that business formations have increased in Wyoming since the launch of Chancery Court. And anecdotally, I can tell you that as I've met with attorneys across the state who do business formation work, they've mentioned to me that when clients come to them, they often cite Chancery Court as one of the reasons for forming a Wyoming entity. So I'd submit that Chancery Court has played some role in this growth. A major magazine, Inc., this media company, published an article recently noting Wyoming overtaking Delaware as a new hub for LLC formations. In July, you may have seen that a big digital asset company moved its offices to Cheyenne. And when you look at these different articles and media reports, you can see that commentators have credited the Chancery Court, among other factors, that are driving this growth in Wyoming. And even if you're brave enough to wade into the comment section, you'll see comments from entrepreneurs about the draw of Chancery Court and what it adds to Wyoming. So the Chancery Court certainly, like other business courts, can help attract and maintain business activity and investment in the state. But not to be lost in this is that the Chancery Court can serve local small businesses with a real Wyoming footprint and a deep communication or a deep connection to Wyoming communities. And when we look at our caseload, it's our business cases, they're roughly split in half between cases involving small businesses with a strong local presence and deep community connection, and cases with Wyoming entities that may have less of a physical presence in the state. So this is all to say that the court can do two things. It can help attract and retain new businesses, new business filings, but at the same time, it can support and serve those small businesses we already have within the state. And so just to summarize the benefits of a chancery court in Wyoming, it gives the state a court that is systematically positioned and intentionally designed to move at the speed of business. It's a court that can foster predictability and certainty by growing a body of decisions that allow for risk assessment. And then this predictability and certainty can attract business and trust activity along with accelerated resolution. Chancery Court can act as a lab for innovation for the Wyoming Judicial Branch. So, for example, Wyoming Chancery Court was the first state court in Wyoming to launch electronic filing, and its practices and procedures are proven useful or effective in Wyoming Chancery Court. They can potentially be adopted in other courts within the Wyoming Judicial Branch. And then the Chancery Court can help preserve Wyoming's first mover advantage in blockchain and digital asset law. So Wyoming's legislature has worked hard to create a legislative framework that deals with these new classes of assets and technologies. But it's fairly easy for another state to take that carefully thought out legislative framework and copy and paste it and establish at its own. What's less easy to copy and paste is a specialized forum that can generate decisions on these new types of assets and technology. So Wyoming Chancery Court has the potential to be a court that can build up a body of decisions and gain some expertise in this area and help preserve Wyoming's first mover advantage in these new and exciting technologies and asset classes. So now that we've discussed where the Chancery Court fits not only within Wyoming, but in a much larger modern business court movement, let me just share how we're doing in terms of the numbers of cases we're seeing, the types of cases we're seeing, and then I'll turn and we can talk a little bit about practice in the Chancery Court and the relationship between Wyoming Chancery Court and Wyoming District Courts, and then I'd certainly be happy to answer questions that you have. So the Chancery Court's early years have shown slow and steady progress. And you can see we went from 15 cases in the first year to 31 cases in the second year to 47 cases in the third year. And this year we're ahead of where we were last year at this time. And now last year we did see a big wave of cases filed in December, so we'll see if we experience that here again. But we're taking this approach of slow and steady development. And our trends align with what scholars and business thought leaders have named the law of diffusion of innovation. And this is a law that shows that innovation spreads gradually with waves of adopters. So innovation is first adopted by early adopters, people who can see the benefits of innovation and have a high risk tolerance. And then they're followed by the early majority who see the benefits reaped by the early adopters. And then the early majority is followed by the late majority. And then we have the laggards who are the last to adopt the innovation. I think Chancery Court represents an innovation to our Wyoming Judicial Branch. And our numbers bear out this theory of the law of diffusion of innovation. We're seeing more and more attorneys across the state litigating in Chancery Court each year. And I'd like to say we're moving from that early adopter stage slowly into the early majority stage for business and trust cases. So early on, we had just a few firms using the court, but by 2023, we've had 47 firms from 10 Wyoming counties litigating in Chancery Court, and we've continued to see uh, different firms from different parts of Wyoming take advantage of the Chancery Court. And it just in the trust context alone, we've had 13 Wyoming firms who have appeared in trust litigation before the Chancery Court. I think our early numbers are hard to evaluate in isolation, but they're promising when uh, compared to the caseloads of other business courts, especially business courts in larger jurisdictions with multiple judges. When we consider Wyoming's population and size, and then you look at other states, it's really promising. So my individual caseload is heavier than Georgia's, than business court judges in Texas and North Carolina. And then Wyoming, interestingly, is keeping pace with Georgia. Georgia is a much larger state, top 10 in terms of GDP and population, and Georgia launched about a year before the Wyoming Chancery Court. Yet we have very similar case numbers, which is an encouraging sign. And then when you compare the Wyoming Chancery Court to smaller states, still larger than Wyoming, but smaller states, are the promising nature of our early case numbers is even more prominent. So, for example, it took Iowa 10 years to reach an annual case load or new case numbers that we reached in 3 years. Our annual caseload doubles West Virginia's and Tennessee's. So let's drill down into the types of cases we see in Chancery Court. And here are primary case types. You'll see that our number one case type is breach of contract. And then our second leading case type are trust cases. And then we'll have internal business disputes. So that's the general makeup of our cases. And then if we look at resolution, you'll see that so far by design, only one case has required the time and expense of a bench trial. All other cases have resolved on paper or resulted in settlement. And this is by design, right? We're trying to resolve cases as quickly and easily as possible while limiting costs for businesses. I should note that in 1/3 of our cases, a party has objected to proceeding in Chancery Court, and then that case has been dismissed by rule. So our rules right now allow any defendant to object to proceeding in Chancery Court. And if that objection is lodged before the defendant's answer or motion to dismiss is due, and if the parties have not previously agreed to litigate in Chancery Court, then the court must dismiss the matter. So roughly 1/3 of our cases have been dismissed after objection. And then here's our resolution numbers by year. This year we've already resolved more cases than all of last year, and we'll certainly add to that number in the next month and a half or so. Let me move now to talking about the relationship between the district court and Chancery Court in Wyoming. And there are two major intersections between these two courts. First, by rule, parties can, in writing, jointly consent to remove a case from Wyoming District Court to Wyoming Chancery Court. Currently, this needs to be done within 20 days of service on the last defendant, but we're looking at some rule amendments that would expand that removal window to make removal more of a practical option for folks. So that's the first intersection. A case can be removed from district court to Chancery Court and become a Chancery Court case. The second major intersection is that legislation allows the Chancery Court judge to accept assignment of district court cases. So these remain district court cases subject to district court rules, but the Chancery Court judge can accept this assignment, and then due to our systematic positioning, we can move them a bit quicker, perhaps not as quickly as our Chancery Court cases, but still at a fairly quick pace. All parties have to consent to assignment to the Chancery Court judge, and then the Chancery Court judge has to accept the assignment, of course. But this provision has really helped supplement the Chancery Court's caseload while the court continues to become more established, and it also allows the Chancery Court to serve as sort of a pressure release valve for district courts, where there are cases with, say, cross-summary judgment motions, or where there are cases that need to be resolved quickly in the district court due to its caseload, just doesn't have the time available to resolve that case. Well, then the court and the parties can discuss the assignment, and the Chancery Court can step in and serve as a pressure release valve and help move those cases forward. Let's continue on this topic of district versus Chancery Court before we get into questions. So I should point out that Chancery Court has its own set of rules. We have our own rules of civil procedure, our own uniform rules, but let me also point out that these are lightly modified versions of the rules applicable in district court. So they've been modified only to reflect the legislatively defined characteristics we've discussed earlier. So these rules are substantially similar to the rules in district court, but you'll see some adjustments to, say, reference the accelerated pace, to call for active case management. Our rules remove any reference to bench trials. But essentially, if you can understand those core characteristics of Chancery, bench trials, accelerated resolution, active case management, limited jurisdiction, then I think you'll be fine moving forward with our rules. So I don't want the fear of or inconvenience of learning a new set of rules to deter you from litigating in Chancery Court. If you can keep these core characteristics in mind, you'll have no trouble, and you'll find that the rules are identical to the rules applicable in Wyoming District Court, which are, for the most part, based off the rules of civil procedure applicable in federal courts. So let me just share what you can expect if you're litigating in Chancery Court. The key difference between practice in district and Chancery Court is cadence, and then I'd say also active case management. So in Chancery Court, you can expect early in the case to invest some time working with the other side and working with the Chancery Court to develop a case schedule and a discovery plan tailored to the needs of the case. So after defendant answers, the Chancery Court will invite the parties to meet and confer and submit a proposed case schedule and discovery plan to the court for discussion during an initial case management scheduling conference. The court will then convene that case management scheduling conference and finalize a case management scheduling order that will govern the case from beginning to end. So it will be a detailed order with deadlines from the beginning to the end of the case. And you can expect the case management scheduling order to call for periodic status conferences. These are brief, remote conferences where the court can ensure the case is following the schedule and where the court can address any issues and get out ahead of any issues before they prolong the litigation. You can also expect that the case management scheduling order will require parties throughout the life of the case to engage in settlement discussion. So typically, the court requires three efforts or three runs at settlement. So we'll require an early case settlement conference, an intermediate settlement conference, and a late stage settlement conference. And typically, the court requires one of those three settlement conferences to involve a mediator. And I've been surprised at how effective these settlement conferences have been at resolving cases, especially early settlement efforts. And now this isn't to say that all cases will look this way. Certainly, we try to customize our case management scheduling orders to the needs of a case. So if we have a case where really the issue turns on interpretation of a provision of contract or trust instrument, and there's not a lot of room for settlement, the court may dispense with those settlement requirements. But for the most part, you can expect a greater emphasis on alternative dispute resolution methods in Chancery Court. I think you can also expect the court to hold as many proceedings as possible remotely, just to increase convenience and decrease costs. And then you can expect a quick turnaround on motions. So as I mentioned earlier, our average is about 10 days or so after close of briefing or close of argument. So the court tries to keep things moving as much as possible. Let's say if you're one of those litigators who spends a lot of time in the trust world, if you file a trust matter in Chancery Court that is contested, then you can expect the procedure that I just outlined. If you file a trust matter that is uncontested, this is what you can expect. The court will review the petition, and before the court does anything, it will ensure that all parties who are entitled to notice of the action under statute have received proper notice or waived notice. And if the notice is proper, those requirements are satisfied, and the requested relief is appropriate, the court has no questions, then the court will enter the requested relief really quickly. If the notice is proper, but say the court may have a few questions or need some clarification on the petition, the requested relief, then the court will contact counsel to schedule a hearing, a remote hearing. We try to do this within 30 days of receiving that petition. Certainly this depends some on how quickly parties receive notice of the petition, but or file waivers of service, but we try to move quickly, hold a hearing on the petition where the court can ask its clarifying questions, and then after that remote hearing, the court will move fairly quickly, and we try to resolve those matters within 5 days after the hearing if possible. So that's what you can expect in Chancery Court if you're filing an uncontested trust matter. Before we get to questions, let me just quickly finish by considering where Chancery Court is headed. We've discussed the progress over the first almost 4 years now, but let's talk about where Chancery Court is headed. As a first full-time Chancery Court judge, I see part of my role as certainly helping establish the court, helping educate the bar and business community about the court, the role it plays, the benefits it offers. But I also see my role as helping promote the Wyoming court system and our favorable business infrastructure nationwide. So one way I do that is through my involvement in the American Bar Association Business Law section, where I'm a presenter and I co-edit an annual and national publication on state business courts. And my co-editor on that publication, annual publication, is a gentleman named Ben Norman, who's a well-established North Carolina litigator who litigates in Delaware Chancery Court, litigates in the North Carolina Business Court. And he was one of the first clerks on the North Carolina Business Court, which was one of the first statewide business courts, and has certainly been one of the more successful statewide business courts. And I just asked Ben, we sat down, I just asked him to compare notes and take a look at any parallels between North Carolina's early days and what it's achieved in Wyoming Chancery Court's early days to see where the Chancery Court may be headed. And my colleague, Mr. Norman, identified 3 keys to North Carolina's growth and success: people, continual refinement, and buy-in. And I just admit that Wyoming Chancery Court has these 3 ingredients for success. Our team, given our lighter caseload, is leaner than the standard district court team. But we're committed to resolving these cases correctly and quickly. So I've served as full-time judge. I have a dedicated staff attorney who has years of private sector experience on these types of cases and who really helps us move forward quickly and meet our deadlines. And we have a full-time clerk of court who also has decades of experience or experiences in court administration. And then I should note that statute allows for the appointment of up to 3 Chancery Court judges. So as our caseload continues to build, there certainly is an opportunity for Wyoming to appoint additional Chancery Court judges so the Chancery Court can stay lean and nimble and resolve cases quickly. But this is our staff for now. And then we also benefit from a dedicated Chancery Court committee that works on refining and evaluating the Chancery Court. And our committee consists of current and former district court judges, a current justice of the Wyoming Supreme Court, a former legislator, district court clerk, and well-respected litigators. And this year, this team of this committee, this Chancery Court committee, has worked on finding ways to continue to refine Wyoming Chancery Court, just as North Carolina has done over the years. And the committee just finished an annual or comprehensive review, really, of Chancery Court rules and practices. And you may have seen some proposed rule amendments circulated this fall for public comment. The committee has received those public comments, worked through them, and is proposing Chancery Court rule amendments for adoption by the Wyoming Supreme Court. And some of these amendments are designed to make life easier on practitioners by, wherever possible, more closely aligning district court and Chancery Court rules, especially on e-filing, things like formats of documents, how things are e-filed. Like I mentioned earlier, we're working on extending the removal window from district court to Chancery Court from 20 days to 60 days after service on the last defendant to make this a more realistic option. I think often in district court, scheduling conference may happen well beyond the 20 days after service. I mean, answers oftentimes aren't even due within that window, so the parties don't have a chance to really get together and consider whether removal is a good option. So we're trying to expand that window. We're also working on introducing a complex adjudication track. So statute calls for most, but not all, Chancery Court cases to be resolved within 150 days of that scheduling order. And there are certain cases that would benefit from the specialization offered by Chancery Court, but due to the unique needs of the case, 150 days is just not a realistic timeline. We could have international discovery. We could just have too many parties, too many claims, too much discovery to allow it to be resolved within 150 days. So we're looking at a rule that would allow the parties and court to designate a matter, a complex adjudication matter that would still move forward and based on expedited basis, but there'd be a recognition that this case will not be resolved within 150 days. And then the division or the Rules Committee, Chancery Court Rules Committee, is still working on considering how we might deal with the current rule that allows any defendant to object to proceeding in Chancery Court. Looking at a way where we can preserve the availability of a jury trial where a defendant really wants and needs one without undermining form selection clauses or efficiency or without increasing cost. So that's the type of work we're doing on continually refining the Chancery Court. And then the last key to success is buy-in. And I certainly recognize that Chancery Court is the new kid on the block. And as I said earlier, litigants have a lot of choices in terms of where to resolve their business and trust disputes. And we recognize that Chancery Court must earn the trust of the bar, the trust of the business community. And the way we're doing that is by providing quick resolutions. I highlighted our timelines earlier, but we're also seeking to publish high quality, timely decisions. So I'd encourage you, if you have any questions about the quality of work or the quality of service that the Chancery Court provides, to go ahead and take a look at some of our decisions to see how we're careful, thorough, and try to correctly apply the law and articulate our decisions well. So in close, before I open this up for questions, let me just, again, thank you for your time and encourage you to consider whether Chancery Court is a good option for your next business or trust dispute, and to consider whether to designate Chancery Court as a form of resolution in your contracts or trust instruments. As I mentioned earlier, I think the court provides a forum for the focused, fast, and fair resolution of business disputes. So let me stop presenting now, and then with the few minutes we have, if there are any questions, I'd certainly be happy to take them. So just go ahead and feel free to ask your question. Looks like we have one hand up. Looks like Deb Balmer. If you want to unmute and ask your question. All right. Let's move on to Mr. Jack Horde.
Yes, I have a question. What do the Chancery Court fees look like compared to district court fees and so forth?
Yeah, good question. So by statute, the fee for filing in Chancery Court is $610. So there's an initial filing fee that's applied to plaintiff when the case is filed, and the amount is $610. So it's certainly more than district court. But when you compare it to other business courts nationwide, it's kind of right in the middle. I think there are some that are well over $1,000 and some that are a little less. But right now, by statute, the filing fee is $610. All right, it looks like Casey has a hand up.
Yeah, I was interested regarding confidentiality because I would assume that some people would say, "Oh, we're not going there because the a decision is going to be posted." Is there a way to not have your decision posted?
Yeah, good question, Casey. And I think that's part of the calculus for parties, right? I think that's the reason why some folks try to resolve disputes in private arbitration, because you get to maintain that confidentiality. I, I think though what you sacrifice is it's a bit more expensive, private arbitration is, and I think Chancery Court moves as quickly, but we do publish our decisions. I'll note that we do not publish our decisions in trust matters. We only publish our decisions in business law matters because there are certain confidentiality protections under statute. But we do publish our business law decisions, and statute does not give us much discretion. Um, so if it's a case where there's no statutory protection on the information, then we are required to publish the decision.
Thank you.
Yeah. All right. Any other questions? And I may not be seeing your hand, so feel free to just turn on your mic. All right. Looks like Jonathan.
So, thank you. If there is a forum selection clause and one of the parties objects, how is that objection to the use of the Chancery Court handled?
So the Chancery Court rules, which allow objection, also allow the Chancery Court to enforce a valid forum selection clause. So if a defendant objects, but there is a valid forum selection clause, then the court will disregard that objection and the case will continue in Chancery Court.
Just as a quick follow-up, is there any model language or are there any cases you could point us to where the forum selection language for the Chancery Court was upheld?
Yeah, good question. Curiously, we've yet to have a case where there's been a dispute over a forum selection clause, where the court has had an opportunity to review and interpret and apply a forum selection clause. So unfortunately, I can't point you to a model clause or a decision that deals with that issue. I am hearing from practitioners across our state that they are increasingly putting forum selection clauses in their contracts that designate Chancery Court. So I suspect eventually we'll get that type of issue. We'll have a chance to interpret and apply and hopefully provide some guidance on forum selection clauses, but that hasn't happened yet. All right, any other questions? And if I'm missing you, feel free to just speak up. I do, just looking at the chat, there's a question of whether the Chancery Court can issue declaratory judgments. And the answer to that question is yes, statute does give Chancery Court a jurisdiction to issue declaratory judgments. So we can deal with cases involving declaratory relief, equitable relief, or monetary relief, as long as the monetary relief exceeds $50,000, not including attorney's fees or punitive damages. Well, not seeing any further questions and seeing that we are coming to the conclusion of our time, let me just again thank you all for your interest in Chancery Court and the time you've spent with me today. I hope this has been informative and helpful, and I wish you all a very good day. Thank you.